So the state laws generally require controllers to conduct due diligence of their processors in order to avoid liability. They're going to incorporate the state comprehensive privacy law terms into their standard terms and expect you to accept them without negotiation. Can you display a cookie consent request if a user has indicated a universal opt-out mechanism?
Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, fantastic. We're back. And we've got Molly Martinson. She's a lawyer at Wyrick Robbins, a Raleigh-based law firm that happens to be very strong in the privacy compliance space. They're also very active in the Research Triangle's privacy community, and I had a chance to listen to her together with Matt Cordell of VF Corporation at the Privacy and Data Security Annual Program of the North Carolina Bar Association, which was very enjoyable, extremely informative when it comes to state privacy laws across the US. Molly advises clients on cross-border compliance, data breaches, CCPA, CPRA, COPPA, HIPAA, and also, data exports from the EU under the GDPR. And she has a pretty impressive academic record prior to this, but I will let you read that in your own time. It's in the show notes. I believe most of the acronyms we'll use are known to all, but just in case, we've added some useful links also in the show notes. Let's go for it. Molly, thank you for joining me.
Thanks so much for having me.
It's a pleasure. To start somewhere, what do we need to know about all of these US laws coming up? It sounds very messy from the outside, and I also wonder, how did we get here?
Yeah, great question. So I'll answer your second one first, which is how did we get here? Your audience is probably already familiar with the CCPA, which is California's version of its state comprehensive privacy law. That law passed in 2018. And since then, legislatures throughout the country have been debating and in a lot of cases passing similar state comprehensive privacy laws. I say similar because the ones that passed after California don't tend to model the CCPA as much as they tend to model GDPR, which we can get into later. But after California passed in 2018, since then, 12 additional states have passed what we refer to as comprehensive state privacy laws. And when I say comprehensive state privacy laws, what I'm generally referring to are privacy laws at a state level that include the kind of central tenets of privacy laws that we've seen throughout the world, like GDPR. And those central tenets are generally individual rights in their data, enhanced protections for certain sensitive types of data, processor or service provider requirements, including flow down requirements, transparency requirements like privacy notices, and security requirements. So that's what I mean when I refer to comprehensive state privacy laws. But there are 13 now to date, with 5 currently in effect.
There's 5 laws already applicable today. Do we expect any others to join them this year? Not as new laws about to pass, but as laws that will become enforceable in 2024.
Yes, there's a couple of new laws that are going to become enforceable in 2024. Oregon, Texas, and Florida all become enforceable in July of 2024. Montana is in October of 2024, and Iowa and Delaware are in January of 2025. So these laws are coming up quickly. So it'll be important to keep your eye out for when the enforcement dates are, but also it'll be important for all privacy practitioners to evaluate whether these laws actually apply to their organization. So, for example, the laws generally have a couple of thresholds that have to be met before they apply to a business. If you're familiar with CCPA, there are a couple of different thresholds that need to be met, including a revenue threshold and a volume of processing threshold. That trend is similar throughout the other states. So in order for the law to apply to a business, the business will need to be doing business in that state and also in some instances meet a revenue threshold, and in all instances meet a data processing threshold where the law doesn't apply unless you're processing that volume of data. So it'll have to be evaluated on an individualized basis.
Do you see, in practical terms, people going state by state, or are we looking at a minimum common denominator as we've tried for a long time, and simply whenever there's a new threshold, then just go for that one? So trying to be on the safe side.
Yeah, that's a great question. I've seen a couple of different approaches that my clients have taken to this question, and I think it really depends on the individual organization's risk tolerance and also the organization's kind of attitude towards privacy protection. So some organizations, for example, one of their, cornerstones of their business model is that they really want to be protective of individuals' privacy. And so they come out and say, we're going to protect your data all the time, no matter what. Those businesses might be more inclined to take a broader approach to state comprehensive privacy law compliance, right? So they might look at their footprint and their processing volumes and say, look, out of the 13 state comprehensive privacy laws, only 2 or 3 apply to us. But because we really want to be protective of our folks' data and not give somebody more rights in their data just because of the state that they live in, they might do the approach of taking the highest common denominator and looking at what the most onerous state laws require and applying that to every state in which they do business. On the other side of the coin, there might be businesses, particularly smaller size businesses, where they don't have the resources to implement that kind of overarching compliance program. And, maybe only 1 or 2 of the state laws apply to them. And so they decide to do a more targeted compliance approach to, just meeting the requirements of those states. If you do take that latter approach, that's fine from a legal perspective, but you will certainly want to keep your eye out for new states that come into effect and also new laws that pass, because you'll have to kind of constantly be seeing if other laws begin to apply to you based on not only new laws being passed, but also changes in your processing activities. So if you process a number of individuals' data that puts you over the threshold, then you'll have to consider that law too. Another point that I wanted to make when we were talking about the volume of processing is it's important to remember that some of these state laws define processing very broadly, and the definition includes storage of personal data. So something that privacy practitioners are going to want to look out for is whether they are storing in existing databases, personal data, even if you're not touching or quote unquote processing based on the conventional use of that term, that still may count towards your processing volume and might put you in or out of scope of a certain state law.
Yeah, like basically the GDPR is everything is processing, a query, viewing data, not even touching it, just a query on a database.
Yeah, and I'm glad you brought up GDPR because those of your audience who are already familiar with GDPR will recognize the primary tenets of GDPR in many of these state laws. So, as I mentioned earlier, California was the first state to pass a comprehensive state privacy law, but the states that followed California didn't tend to copy CCPA as much as it copied the tenets of GDPR. So Virginia and Colorado were among the first to pass these laws after California, and both of those laws are very similar to GDPR in terms of um, not only the rights that are afforded to individuals and the requirements, but also kind of just some of the language. For example, they refer to controllers versus processors, and some things like that.
I was about to ask you that. How, what do they look like? Because in the end, if California is a bit of a one-off, how did the others evolve? Do they copy each other? Do they all copy Virginia? How did that play out?
Yeah, so Colorado and Virginia, like I mentioned, were the first states to come after California, and those laws look very similar to GDPR. So some of the kind of central tenets of the state privacy laws are a couple of different components are included in all of them, right? So you have individual rights in their data. So that includes the right to access, the right to delete, the right to correct in certain but not all instances, the right to opt out of certain activities such as sale of data, sharing of personal data, targeted advertising, profiling, and automated decision making. For those of your audience that are familiar with GDPR, a lot of those individual rights are the same as GDPR. For example, the delete right is the same as the kind of right to be forgotten as it's understood in GDPR. Um, so individual rights are a primary component of all of the comprehensive state privacy laws. The other big items within these laws are enhanced protections for sensitive personal information, certain requirements for processors or service providers, such as contract requirements, transparency requirements. So they're all going to require you to have a privacy notice that includes certain content to let individuals know how you're using and processing their personal information. And there's also generally a security requirement that tends to be broad and not prescriptive. So, for example, the laws will say that you have to implement reasonable security measures or something similar.
It sounds overwhelming, and I guess people are wondering whether they can leverage anything they already have in place in terms of a privacy program, or how would you suggest they tackle this avalanche?
Yeah, I think companies can definitely leverage existing processes that they have in place for compliance with other privacy laws that have been in effect for a long time, like GDPR or CCPA. So if your company has already developed a GDPR compliance program or a CCPA compliance program, there's several features or infrastructure that you've likely already developed that you can incorporate state privacy compliance into those processes. So, for example, you've likely already developed a data inventory or data mapping process. That'll be key for compliance with state privacy laws, not only for figuring out whether the law applies to your company, but also for figuring out, where your data lives, what type of data you have, whether you have sensitive personal information. That's always going to be kind of step one in any good compliance program. Another process that companies can likely leverage for compliance with the state comprehensive privacy laws are any kind of consumer request and verification process that you've put in place. So, for example, if you already have set up a web portal for individuals from California to fulfill their individual rights, that'll be a great place to just kind of tack on any additional state laws that you are having to address. DPIAs, we didn't touch on that much, but GDPR has a DPIA requirement that folks are probably already familiar with. That's a great tool to be able to use under the state comprehensive privacy laws because those privacy laws also require special assessment of data processing activities if a heightened level of risk is associated with the processing that you're undertaking. So the DPIA process that you've already got in place for GDPR will likely be really helpful for the state laws.
Okay, very good. So then you've mentioned one thing that is driving me crazy these days, which is vendor audits and management of the chain of custody beyond your own systems. So data processors and then sort of third parties that will receive the data. And how does that work? What should companies be thinking about when it comes to vendor service provider relationships?
Yeah, so there's a couple of different aspects of the vendor service provider relationship that come into play under these new state privacy laws. You mentioned auditing. That's definitely one big one. So the state laws generally require controllers to conduct due diligence of their processors in order to avoid liability for the acts of those processors. So from a risk management perspective, it's going to be important for data controllers to check into the vendors or service providers that they're using and make sure that they not only are saying that they do comply with applicable state laws, but also that they have the kind of infrastructure and abilities to comply with those laws. There's a variety of different ways in which businesses can conduct these audits. The most common one that I see among my clients is the creation of a vendor audit questionnaire where the controller asks a series of questions related to the vendor's ability to not only comply with laws, but also comply with the controller's instructions relating to fulfilling the laws. So, for example, one of the important rights under the state comprehensive privacy laws is that individuals can go to the controller and say, delete my data, give me access to my data. And that right can't be fulfilled unless all of the downstream vendors or service providers that the company shares personal information with have the ability to, cull up that data to give access or delete it on a downstream basis. So the vendors or service providers have to be able to respond to those types of requests from the controller. And this vendor questionnaire tends to try to suss out the vendor's ability to do so. So the due diligence and auditing piece is going to be important for any company to be able to demonstrate compliance with the state privacy laws. The other aspect of vendor relationships that comes to play under the new state comprehensive privacy laws is I mentioned earlier that one of the primary features of the state laws is that it gives individuals the right to opt out of the sale of their personal data, among other things. And the state laws generally have an exception to the definition of quote unquote sale that excludes disclosures to vendors and service providers. So to the extent that your company is sharing an individual's personal information with a vendor or service provider to provide services to the company, then that's not a sale. And these onerous like sale opt-out obligations don't flow down to that vendor. So the implication of that is that companies are going to want to solidify, I guess, or shore up their vendor relationships to ensure that any vendor or service provider that they are using are appropriately characterized as a vendor or service provider under the law to make sure that they are protected by that exception. So one of the things that companies will need to do if one of these state comprehensive privacy laws applies to your company, then you'll need to make sure that you are including in your contracts the terms that are required to be put in place between vendors and controllers under the laws. So for those of you who are familiar with GDPR, you'll be familiar with the Article 28 requirements, and the comprehensive state privacy laws have a similar flavor, I guess, as the Article 28 requirements, where it says if you use a vendor to process personal information, you have to have these contract terms in place. So you'll want to make sure that you're checking your template agreements with your vendors to ensure that the required terms are there. And the kind of goal of that process is to make sure that that vendor is properly characterized as a vendor or a service provider.
Do we do the same thing in the US or in most states, or maybe in some states, as we do in the GDPR, with the DPA, the Data Processing Agreement? It's a separate document. It's an annex, a separate contract, or can these clauses be bundled and be integrated into a more generic, contract for the provision of the services?
Yeah, there's nothing in the law that says that that these contract terms have to be separate or in some kind of separate addendum to the contract. So they can be bundled into a services agreement. I think it just would depend on your company's kind of relationships with their service providers, right? So you don't have to have these contract terms in place with service providers that are not processing personal information. So if you incorporated those terms into your just kind of general services agreement, it might be overly burdensome in instances where it's not applicable. And I think that's why people tend to have it in a separate addendum, so they can just attach it where it's applicable. But there's flexibility to really do it either way.
Yeah, also this imbalance in terms of negotiating power, where very large suppliers have more power than their customers when you're dealing with a Salesforce and the Microsoft, and they simply have these pre-built contracts, even made public on a repository of sorts, and you just go there, and if you like it, you sign it, and if you don't, you just don't buy it,
Yeah, definitely. That's something that we've seen, and I expect we will continue to see, is the large service providers like Microsoft, Salesforce are going to, if they haven't already incorporated, they're going to incorporate the state comprehensive privacy law terms into their standard terms and expect you to accept them without negotiation. That's another area where vendor diligence can come up as a question because, like I mentioned before, a mechanism for auditing vendors to ensure they can comply with comprehensive state privacy laws is sending out a questionnaire and asking the vendor to respond to your questions. But that endeavor would be a little bit silly for companies like Amazon or Microsoft, which would not entertain responding to your questionnaire. So in those instances, I've found that those larger companies tend to, post in a publicly available location information about their security posture, their privacy posture. Maybe they post their SOC 2 or provide a copy if you request it. And that's pretty much as far as they're going to go. But I think the community is relying on the idea that these bigger companies have proper protections in place. And if they don't, we're all going to be out of luck.
Yeah, I know that we've had to go through the documents that were made public to score the DPAs, in a way that we can at least compare them with other suppliers, since we knew that no one was going to listen if we sent a questionnaire. But I see there's more people doing the same thing, sort of scoring and scanning through the DPAs, looking, for example, for data transfer tools when customers are in Europe, whether they use the data privacy framework or whatever they're mentioning in the DPAs. So you mentioned privacy rights when it comes to individuals, and you mentioned sensitive personal information. What is that when it comes to the U.S. or state comprehensive privacy laws? Do they differ? How do they deal with sensitive personal information?
Yeah, so this is another instance where you can really see the state legislatures borrowing concepts from the GDPR. So you may know already that under the GDPR, there's a concept of special categories of personal data, and that is information such as health data, genetic data. It's its own category of particularly sensitive types of personal information. Um, the US state privacy laws also have a concept built into all of them of sensitive personal information, where the idea is that these types of data are so sensitive that we should protect them in a special way or protect them in a more heightened way than regular types of personal information. So each state has its own definition of sensitive personal information, but generally speaking, types of data that are considered sensitive personal information under the state privacy laws are things like, data revealing racial or ethnic origin, religious beliefs, mental or physical health diagnosis, sexual orientation, genetic or biometric data, used for the purposes of identifying an individual, information obtained from children, and things like that. The protections surrounding sensitive personal information vary pretty substantially between the states in terms of how businesses are required to give individuals rights in their sensitive personal information. So the states will vary as to whether they give individuals the right to opt into the processing of their sensitive personal information or opt out of the processing of sensitive personal information. Obviously, opt-in is the method that is more onerous for businesses, but opt-out isn't without compliance challenges either. So right now, opt-in is the majority of the states. So those state laws say that you cannot process an individual's sensitive personal information until the individual opts into your processing of that type of information. The states that are opt-in right now are Colorado, Connecticut, Delaware, Indiana, Montana, Oregon, Tennessee, Texas, and Virginia. Whereas Iowa, Utah, California, and Florida give individuals the right to opt out of the processing of their sensitive personal information. So this is going to be a concept that should be at the top of businesses' minds to the extent that they process personal information about individuals that could fall into that sensitive personal information category. You're going to have to take that next step of either giving individuals the right to opt in or opt out of that type of processing. And that's going to require some kind of interfacing with the consumer in order to have them make that choice.
It's quite surprising that Texas is an opt-in and California is an opt-out. It's not what you would expect, in any sort of, at least coming from the outside. But I'm thinking that maybe it's not so important because there's a bit of an overlap with federal law, right? I've seen the FTC going after companies that were using sensitive data in the context of online behavioral advertising. So using not only health data, as in the case of like GoodRx or BetterHelp, but also even financial data. And then there's children. Children are covered by COPPA, right, at federal level. So isn't there a bit of an overlap when it comes to sensitive personal information?
That's a great point, Sergio. Something that companies will need to remember, particularly if they're processing sensitive personal information, is that the state privacy laws are certainly not going to be the only privacy-related laws that you're going to have to consider in your business activities. So you gave the example of children. That is certainly right, that companies will have to evaluate if they are processing personal information of children. They'll have to evaluate not only what they need to do under the state privacy laws, but also under federal laws like COPPA. Another area where this comes into play is health-related data. So the state comprehensive privacy laws generally kind of lump health-related data into the definition of sensitive personal information. But a trend that we're seeing throughout the country is states also passing laws that are designed to protect individuals' health information that are separate from these comprehensive state privacy laws that we've been talking about. So businesses that are processing sensitive personal information are just going to have to evaluate their compliance obligations under a variety of laws in the US. That's kind of the nature of our patchwork system, and it's what we have to deal with.
True. There's this my health, my data thing now, right?
Yeah, so the state of Washington passed My Health, My Data last year. That law has already had certain components of it come into effect last summer, but um, the majority of the law is coming into effect on March 31st, 2024. And that law is a good example of one where the state comprehensive privacy law. There is not a state comprehensive privacy law in Washington, but there is this My Health, My Data Act, which covers consumer health data and can have broader applicability outside of just the state of Washington. So particularly companies that process individuals' health information are going to have to be aware of the whole patchwork. And you're right that it's likely that they'll have to be considering implementation of opt-in or opt-out anyway. So this comprehensive state privacy law may not be a big lift in terms of compliance if they've already kind of done some of the legwork for the other laws that apply.
It is interesting to find a common denominator when it comes to consent, and that's something that I'm pretty obsessed about when it comes, in the overlap of marketing technology, advertising technology, social media, publishers, and privacy. And something that I think is very useful and really good news coming from Europe and from the nightmare of consent pop-ups that we ended up with is that first in California, I believe now in Colorado and other places, there's this an understanding that if you allow people to use their browsers to define their opt-in or opt-out preferences, that then you can spare them the pain of having to click on accept or reject, through these annoying consent pop-ups through consent management platforms. And I've only seen 2 states. What do you think about that, about global privacy control?
Yeah, so that's a great question. The state comprehensive privacy laws actually do address the concept of universal opt-out mechanisms, including that there are 7 of the state comprehensive privacy laws that will require businesses that operate websites to detect and honor universal opt-out mechanism signals. But there are still a lot of unanswered questions surrounding the concept of universal opt-outs as it relates to these comprehensive state privacy laws. So, for example, the 7 state laws that I mentioned say that website operators have to detect and honor those signals, but they don't, on the face of the law, give much more detail about how those requirements will play out operationally. So, for example, some questions that I can think of that are still outstanding that no law has addressed, at least on the face of the law, is like, can you display a cookie consent request if a user has indicated a universal opt-out mechanism, or if the universal opt-out mechanism signal conflicts with the user's choice on a cookie consent, what happens then? So I think there's still a lot that's left to be fleshed out once these laws come in effect. And therefore, I think businesses still do have some leeway in how they implement universal opt-out mechanisms on their website, but you'll have to keep in mind, if one of these 7 state laws apply to you, that the law says that your website does have to detect and honor the signal.
Molly, thanks again. Very useful. Thank you.
Thank you so much for having me, Sergio. It was great to talk to you.
Okay, that's all for today. Please help us gain some visibility and grow in every sense of the word by hitting 5 stars on whichever podcast player you use if you think we deserve them. And remember that you will find some episode notes and links to our social channels on mastersofprivacy.com. Thank you for listening.